Good morning. Good morning, all my students. Good morning. We are going to have an online lecture this morning. Okay, so we are going to start this lecture in a few moments. Okay, so all my students, please come to this online classroom. Okay, I'm going to proceed to my desk in order to deliver my lecture right now. Okay. Okay, good morning again. Okay, today there is going to be a lecture again on the topic of the doctrine in the English contract laws. Okay, I think that you can remember the lecture last week. We spent some time talking about English doctrines in English contract law. Okay, these are the doctrines which are intended to make sure that the intentions as declared by the parties is going to be a real, a genuine, and a free intention. Okay, so in order to make a contract, the parties to the contract need to have intentions which are free, which are also genuine. Okay, so there are, of course, in the laws of almost all jurisdictions. Okay, the doctrines or principles of law which are intended to protect, okay, the intentions of the party, okay, against something wrong. Okay, so that we have seen the factors which may vitiate intentions of the parties, okay, in Thai law. And remember, we explore English laws for the purpose of your comparison with Thai law. Okay, last week we talked about English law, English doctrines of what? Of misrepresentation. We have also talked about English doctrines of Duress. Okay, so then this week we are going to talk about the English doctrine of what? The English doctrine of undue influence. Okay, which is going to throw some light on how to how to develop Thai law. Okay, we can see that in some situations. Okay, Thai law does not protect parties, okay, against vitiation of will. Okay, so if we look at English law, we will see that maybe in the same scenarios, okay, parties, if the contract is governed by English law, parties can be protected by English law. Okay, the doctrine which is known as the doctrine of undue influence, it is one of the doctrines which gives you some explanations on the how Thai law is quite insufficient, okay, in terms of protecting parties against vitiation of will. Okay, so now let's look at the nature of undue influence. What is it when we talk about undue influence? Okay, the doctrine of undue influence is indeed something which is also related to the doctrine of Duress, which we talked about last week. Okay, remember last week we talked about the doctrine of Duress. Okay, Duress is what? Duress is some kind of, the extension of a threat. Okay, the doctrine of undue influence deal with undue influence. So what is it when we talk about undue influence? Okay, when we talk about undue influence, what is it? Is that something the same? It is something identical to, or it is something different from Duress. Okay, given that Duress is concerned with a threat, okay, undue influence it is also something to do with what? To do with the influence. So you may think that influence is some kind of threat as well. Well, we can see that sometimes the influence in question is comparable to a threat in the same way as Duress, but sometimes, okay, in some situations, influence in question may not be the same as a threat. Okay, in the same way of the Duress at common law. Okay, so in a way, in undue influence, it is sort of the influence which is exerted by one party on the other party in order to obtain some benefit from the contract, okay, from the transaction in question. Okay, so in English contract law, okay, there is this doctrine, okay, to protect the parties, okay, against this kind of inference. Okay, so before going to the types of inference in English law, okay, we are going to look at the consequences of undue inference first. If a contract is made under undue inference, then the contract in question will become voidable. Okay, so that means that the person who is injured, the person who is aggrieved by the exertion of undue inference, may decide to set aside the contract. Okay, so for one thing, okay, the doctrine of undue inference, this is the doctrine in equity. Okay, I don't know whether you know equity. Okay, in England, okay, in English law, there is the common law, and there is also what is known as equity. Okay, the rules at common law, they are the rules which have been created, which have been established by courts. Sometimes when courts have established some rules, the rules which have been established by the court, the rules which have been made by the courts may be rigid. So that's why sometimes when the court feel that the rules which have been established by the courts become too rigid, okay, and lead to some injustice, then the court will take the opportunities of establishing, the rules which are intended to fill the rigidity in the common law. Okay, the rules which are established by the court in order to fill rigidity. Okay, they're left by common law. That those rules are referred to as the equity. Okay. Sometimes we call those rules equitable rules. Okay, the term equitable rules, they are the rules which have been created in equity. Okay, the rules which have been created or which have been made by courts. Okay, there are two wings. Okay, there are two prongs of the law. The law which is made by judges. The first set of rules, it is the set of common law, and the second set of rules, it is a set of equitable rules, or the rules in equity. Okay, so undue inference doctrine, it is a doctrine in equity. Okay, it is called also the equitable doctrine. Okay, when we talk about the doctrine in equity, you may use the word equitable. Okay, equitable doctrine in equity, or equitable doctrine. These two terms are interchangeably used. Okay, so now you may wonder, what is the significance of equitable rules? It is an equitable rule when we say that this rule is an equitable rule. This is something important, because it will just tell you that it is not your own right. It is going to be invoked only by the court. It is up to the discretion of the court. Okay, when the facts in this case occur, then it is up to the court to invoke this rule or not. If the court thinks that it is proper to invoke this rule, the court will invoke this rule. But if the court thinks that this is not quite proper, this is not quite necessary to invoke this rule, the court will not invoke this rule. Okay, so it is not the right of the party, okay, to have the contract governed by this rule. Okay, it is up to the court to invoke it or not. Okay, so now when we look at the general nature of inference, or the undue inference, okay, we have seen that undue inference, it is the inference which is exerted by one party on the other party. A makes the contract with B, so A just exerts, okay, some influence over B, okay, in order for B to enter into the contract with A. Okay, so there are two types of undue influence. The first type is called actual undue influence. Okay, the second one, it is called the presumed undue influence. What is the difference between the two? Okay, the actual undue influence, it is the influence which is actually exerted on the other party. Okay, so when A makes a contract with B, A exerts influence on B. Okay, A actually exerts influence on B. Okay, so this is the actual undue influence. But when we talk about the presumed undue influence, as the name suggests, okay, this influence, the undue influence is not actually exerted on the other party, but it is presumed by law to have been exerted by one party on the other party. Okay, there are some circumstances, okay, which gives rise to this presumption. Okay, the presumption that the first party A has exerted, okay, some influence on the other party, or B. Okay, so this is the influence which is presumed to have been exerted by one party on the other. It is not actually exerted by one party on the other party, but it is presumed by law to have been exerted by one party on the other party, and there are some circumstances which gives right to this presumption. Okay, so we will talk about that later. Now we begin with the first type, of undue influence, that is the actual undue influence. Remember, the actual undue influence, it is the influence which is actually exerted by one party on the other. Okay, so in a way, it is something which is similar to Duress. In fact, it may be the same as Duress. Okay, remember when we talk about Duress, we talk about it. When we talk about Duress, we have seen that Duress, it is a what? It is a threat exerted by one party on the other. Let's say that I tell you that, well, if you do not want to make a contract with me, I'm going to attack you now. If you do not want to make a contract with me, I'm going to just burn your house, something like that, okay? And if you can remember, okay, in the English law, the doctrine of duress is broad enough so as to also cover, the situation which is known as economic duress as well, a threat to cause some economic catastrophe, okay, on the part of the other party. A wants B to, to just increase the price for A by, let's say that 10%, okay, and A tells me that if B does not want to increase the price for this under this contract by 10%, then A is not going to, to just perform the obligations under this contract. Okay, so B is afraid that, the contract between A and B is going to be broken. Okay, if the contract is broken by A, then it will cause a lot of economic catastrophe on B. Okay, so in this case, B may agree, okay, to increase the price for A by 10%. This is also duress. Okay, duress, which is known as economic duress. We have seen that duress in English common law seem to be very, very broad. Okay, so when A just exerts, the address on B, okay, it is duress, but it can also be undue influence. Okay, look at the case on the screen now. Okay, we have the case known as William and Bailey here. Okay, in this case, what happened is that a son, the son, of somebody just forged, the father's signature, okay, in order to enter into a transaction with a bank. Of course, the forgery constitutes a crime, of course, right? Forgery constitutes a crime, so that in this case, when the son just forged the father's signature in order to enter into, let's say that, a contract with the bank, in this case, the bank could just press a criminal charge against the son, okay? So in this case, the bank just demanded the father to just mortgage the father's property to the bank, okay, in order to secure the son's debt. The bank tells, in this case, the bank told the father like this. The bank told the father, well, the gentleman, your son has committed something wrong. Your son has, forged the check. Your son has forged in the, signature, okay, in making transactions with the bank. So this is a criminal offense, so you should be mindful of this, okay? And we, the bank, can just, bring your son to justice, okay? We can just, in fact, to bring the legal proceedings against your son, okay? If you do not want your son to be, taken legal proceedings against, why don't you do this? You just mortgage your property. You just mortgage your house as security, okay? As security for the son's debt. Then the father was worried that the son would be taken legal proceedings against, right? So the father in this case would have no choice. Okay, the son did not want, the father did not want the son to be put in jail. Okay, so the father agreed to, conclude a mortgage in favor, in favor of what? In favor of the bank here. Okay, so as demanded by the bank, of course. Okay, so in this case we have the what? We have a contract, of course, between whom and whom? Between the bank and the father. Okay, the father of this man, the man who committed a crime. Okay, so later the father argued that this mortgage, this agreement was not valid. This agreement was voidable because of what? Because of undue influence. Okay, because in this case we can see that in fact the father did not want to make, did not want to conclude this mortgage in favor of the bank. Okay, the reason why the father just agreed to just conclude the mortgage for the bank was that the bank just exerted a threat over the father that if the father did not agree, then the bank would just press a criminal charge against the son. Okay, so you can see that, well, this is something similar to Duress, right? Well, in this case means that you may wonder why this case falls within the ambit of the doctrine of undue influence. Okay, could we just apply the doctrine of duress? You have to recall that in the old days, remember, in the old days the doctrine of duress was very, very narrow. In the old days the doctrine of duress was limited in its application to which case? To cases involving duress to the person only, i.e. the threats. A threat to do what? A threat of physical violence. Okay, a threat to cause bodily harm. Okay, if the threat in question was not the one to cause any bodily harm, it would not be duress. In the English law, remember, in those days the doctrine of duress seemed to be very, very limited, so that when common law did not sufficiently protect the people, then the courts decided to just establish new rules. Okay, the new rule. Okay, the court just established the new rule as the equitable rule. Okay, so this rule, it is the rule in equity. Okay, the rule which has been established by the court, it is known as the undue influence doctrine. Okay, so in the case like this, even though in those days it did not trigger the doctrine of duress, because the threat in question, it was not the threat to cause bodily harm, but the court just was of the view that, well, it was on sale, some undue influence, okay, which should not allow the contract to stand. Okay, so the court established the doctrine of undue influence. Okay, and the result is that a contract which was made under undue influence, okay, would be voidable. Okay, the contract which was made, okay, in this case, the contract here is the mortgage. Okay, the mortgage which was made under influence, and that was the actual undue influence, because it was the influence actually exerted by the bank on the father here. Okay, so that the contract just became voidable on the ground of undue influence. Okay, so we can see that with respect to actual undue influence, we can have some overlapping, okay, between the doctrine of duress and the doctrine of undue influence. As I have explained to you, the reason why this case triggered the doctrines of undue influence, right? Because in those days the doctrine of duress did not become broad enough to cover this. But later, when the courts have expanded the doctrine of duress to be very, very broad in its application, okay, it covers duress to the person, it covers duress to goods, and it covers also economic duress. Okay, and as we have seen, okay, in modern days the courts do not just classify the Duress in any category. The court do not need to just place this kind of Duress in the the category of Duress to the person, Duress to goods, or economic Duress. Okay, the court seem to just the merge all Duress cases and then have them governed by what? By just one category of Duress. Okay. Any threats which leads the other party to the no practical choice situation, okay, will be Duress at common law. Okay, so now today, when we have the case like this, when we have cases like this, okay, the cases like this will trigger both the doctrine of Duress and the doctrine of undue influence at the same time. Okay, so but in those days, the doctrine of Duress became so narrow. Okay, that's why the court established the new rule, the undue influence doctrine, in order to have to have the parties who suffer injury, okay, due to the undue influence. Okay, so now if we just compare this position, okay, in English law with the one in Thai law, remember we have the facts like this. In this case, in William and Bailey case, okay, the father concluded a contract in favor of the bank because the bank, okay, exerted threats on the father that if the father did not do so, if the father did not conclude this mortgage in favor of the bank, then the bank would have to just press a criminal charge against the son. Okay, would that be Duress? Would that be Duress in Thai law? In Thai law here, okay, if the father, if the father was in this situation and let's suppose that the contract was governed by Thai law, would this father in this case, have any remedy? The answer is no. If you can remember, okay, of course, in this country, in Thailand, we do not have the doctrine of undue influence, but we have the doctrine of Juris. We have the principle. We have the principle of law, okay, regarding Juris, okay, and you should just recall that in this country, okay, this kind of Juris does not constitute Juris. This kind of threats, okay, does not constitute Juris in Thai law. You have to just recall, what is said in what it says in the, in Thai law. Remember now, in the section in section 165, okay, in Thailand, what is said in the civil and commercial code is that a threat to resort to the normal exercise of a right under the law will not be Juris in Thai law. Okay, this is the position, the position embodied in section 165 of the civil and commercial code. Okay, I think that when we have taken the lessons on this, okay, remember there are also some cases in Thai law which are in fact very similar to the case which I have brought to your attention, okay, English case which I have brought to your attention, okay. We have seen the case of Williams and Bailey here, okay, regarding, the threats exerted by the bank on the father, okay, of a man, okay, in a way that if the father did not mortgage his property in favor of the bank, then the bank would have to press a criminal charge against the son, okay. So it was here that, this threats constitute undue influence, which would of course make a contract in question voidable, so that the father could just set aside this contract. Okay, in this country we have some cases with similar facts. I think that you can remember one of the cases which have been brought before the Supreme Court. Remember in this case, the case reported in 1990. Okay, the Supreme Court case. Remember that in this case, if you look at this diagram again, we have taken the lesson on this, but I'm going to put this back to you in order for you to have some comparison with English law. Remember, one person just borrowed money from the lender, right? And this person also stole some property from the lender as well. Okay, so in this case, let's say that this man is A just borrow money from B is the lender, right? And A also stole, the property from B as well. So in this case, A committed the crime, of course. Okay, so when A committed the crime, right, B had the right to do what? B had the right to just press a criminal charge against A, right? In fact, in this case, the lender who became the victim of this crime reported this incident to the police, and A was in custody by the police at the police station. Okay, so in this case, B contacted, A's father, and B just told the father about, the son's commission of the crime. Okay, so the lender here told the father to do what? To just enter into a memorandum of agreement with the lender, okay, under which the father agreed to do what? The father agreed to just make repayment to the lender, okay, in the amount owed by A to B, in the amount owed by this man, okay, the man who stole the property from the lender, okay. So under this, memorandum of agreement, right, the father promised to make repayment of the money, okay, to B. So we have here an agreement between whom and whom? Between the lender and the father, right, the father of the one who committed the crime, okay. So the question which arose and which brought before the Supreme Court was whether or not this kind of threats constitute duress, which would make this memorandum of agreement voidable, okay, under the civil and commercial code, okay. And then it was held by the Supreme Court that no, okay, this kind of threats did not constitute, duress according to the civil and commercial code. Because of what? Because the civil and commercial code says that a threat to resort to the normal exercise of a right, it is not regarded as duress in Thai law. Okay, in this case, the borrower simply had the right to just press a criminal action against A, right? Because B, the lender was the victim of the crime. Okay, so the victim of the crime had the right under the law to just take the criminal to justice. Okay, so in this case, a threat like this, it is a threat to resort to the normal exercise of a right. So it is not duress in Thai law. So put simply, okay, the fathers in this case would have no remedy. But if this case, was governed by English law, then we can even, resort to the authority, let's say authority in Wyndham and Bailey. We can also trigger, okay, we can just call into play the doctrine of undue influence in order for this contract to be voidable, okay, and to be set aside. Okay, so we can see that, from this case, if we compare, the case, the William and Bailey case, and this case in Thailand, we can see that similar facts lead to different consequences. Okay, in English law, these facts will make the contract in question voidable, but in Thai law, similar facts here would not make this contract voidable. Okay, so we can see that the English law seems to protect parties more effectively. That's why I try to just encourage you to think whether or not, okay, it is true. Whether or not it is true to say it is correct to say that the English law is broad. Okay, English law is much broader than Thai law in terms of protecting parties against vitiations of will. Okay, in order to just make sure that the will of the party is free, genuine, okay, it's free and genuine, okay. So I think that you have the picture, the clear picture of this. In fact, in Thailand, we also have this case as well, and I hope that you can recall this case. Remember the facts of this case. In fact, we have taken the lesson on this point. Remember, somebody just drew a check without sufficient money in his own bank account, and in this country, in Thailand. Remember, we have the law, we have the legislation called, and the called what? Called the act on offences from the use of checks. If you draw a check without sufficient amount of money, okay, without a sufficient amount of money in your bank account, that is an offence under this act. So this man drew a check. This man drew a check without a sufficient amount of money in his bank account, so that it constitutes a criminal offence under this act. Okay, so the drawee here, the one who received the check, okay, threatened like this. The drawee of this check just exerted threats on this man, okay, forcing this man to do what? Forcing the drawer, okay, to just make a loan agreement, okay, with the drawee, okay. So we have a contract here, the loan agreement between the drawee and the drawer here, okay. And under this loan agreement, right, of course, I mean the borrower, the drawer would become the borrower, okay, and the borrower would have to pay the money to the lender, the lender who was the lender here, of course, the drawer here, okay. So we have a contract here. The contract in question was a loan agreement, okay. So we have to consider whether or not this loan agreement was, the invalid, or it was, the voidable on the ground of Duress. Remember, it was here that the threat like this was not Duress in Thai law. Why? Because it was the threat to resort to the normal exercise of a right. This drawee, okay, had the right to just take legal proceedings against, the one who committed the crime. So when the drawee exerted threat like this, it was the threat to resort to the normal exercise of the right, which would not constitute duress in Thai law, according to the civil and commercial code of Thailand. So that we can see that in this situation, even that this man, okay, the drawee who was forced to make this agreement, could not have any remedy, okay. But if this case is governed by English law, then the result will be different, okay. If this case is governed by English law, then this man, the borrower, the one who was forced to make this loan agreement, okay, would be allowed to ask the court to invoke the doctrine of what? The doctrine of undue influence, in order that the contract, the loan agreement would be pronounced by the court as voidable. Okay, so from these two cases in Thailand, okay, we can see that, okay, English law seems to be much broader than Thai law. Okay, so now, right, as I have said, with respect to the actual undue influence, it just overlaps with the doctrine of duress. Right. So now, when the doctrine of duress in English common law seems to be expanded to be broad in its application, okay, it covers duress to the person, it covers duress to goods, and it also covers economic duress. Okay, it covers all threats which produce the consequence that the party who is threatened will have no practical choice. Okay, so when the doctrine of duress covers all threats, that means that with respect to the actual exertion of threats, okay, like what happened in the in William and Now, okay, now, cases like this will also trigger both doctrines. Doctrines of what? Doctrine of Duress and also doctrine of undue influence, okay? Because the doctrine of Duress now has been expanded by the court to be very broad in its application. So, in practice, most cases which are concerned with undue influence are cases which involves, what is known as undue influence, i.e. the influence which is not actually exerted by one party or the other, but it is presumed by law to have been exerted by one party or the other, okay? So there is the legal presumption of undue influence. It does not mean, however, that, in all situations the law will simply presumes that one party has exerted undue influence on the other. Okay, the law will just presumes this only when there are some special circumstances. Only in some circumstances the law presumes that one party has exerted undue influence on the other. Okay, so if the law presumes that party A has exerted undue influence on party B, then the contract between A and B will be voidable, and the party who suffers injury may just set aside the contract. Okay, so the circumstances which gives right to the legal presumption of undue influence are as follows. Firstly, there must be some special relationship. Okay, some special relationship between the parties. We may call this one as a special relationship or a relationship of confidence, or sometimes we call this one as a confidential relationship. Okay, in the second element, okay, in addition to the fact that the two parties must have some special relationship, okay, the parties must also have sort of manifest advantage in the sense that, okay, one party has obtained a manifest advantage from the other party. A contract is made between A and B, and this contract confers upon A manifest advantage. Okay, so now we are going to have a look at these two elements in order to trigger the legal presumption of undue influence. Okay, with respect to the first element, okay, the first element, it is element of what? A special relationship between the parties. The question here is what kind of relationships are considered as special relationships. Okay, in this case, if we look at case law, the courts through decisions, okay, have announced many relationships as special relationships. Okay, we get through case law a relationship between a lawyer and say a client, or a relationship between a parent and a child, or a relationship between a trustee and the beneficiary. In these cases, the law have established special relationships. Okay, so if the contract is made between these parties, lawyer and client, parents and a child, or a trustee and the beneficiary, okay, this contract, it is made with some special relationship. Okay, but that is not enough to trigger the legal presumption of the undue influence. In order for this presumption of undue influence to arise, okay, there must be, again, the second element here, the manifest advantage. Okay, you have to look at this diagram in order to have proper understanding on this point. Let's suppose that we have a contract between A and B. The very first thing to have been, okay, the very first thing which need to be established before the law presumes that the contract between A and B has been made under influence is that A and B have some special relationship. Okay, let's suppose that A is a lawyer and B is a client. In this case, let's suppose that the contract between A and B, it is a contract of sale of land. Under this contract, the lawyer just buys this land from the client at under value, okay, the land real value is say 2 million baht. The lawyer has purchased this land from the client at a price of say only £200,000. Okay, the land is worth not baht just now. I just meant to say that the land is worth 2 million baht. Let's change it to 2 million pounds. The land is worth 2 million pounds. The lawyer just has purchased the land from the client at the price of just the 200,000 pounds, even though the real value of this land is 2 million pounds. So that in this case, we have this question: is the contract between the lawyer and the client here voidable on the ground of undue influence? Well, it is not the case of actual undue influence, but can it be the case of presumed undue influence? Well, in order to be the case of presumed undue influence, okay, we have to establish first that the two parties, the lawyer and the client, they have a special relationship, okay? On this point, there is no problem because it has been established by the courts to case law that the relationship between the lawyer and the client, it is a special relationship or a relationship of confidence, okay? So we have to move on to consider the second element here, manifest advantage. From this transaction, we can see that the lawyer has obtained, obviously, a manifest advantage from the client because the real value of the land is 2 million pounds, but the lawyer has obtained this land, okay, from this sale at the price of just 200,000 pounds. So that, okay, in this case, the lawyer has obtained apparently a manifest advantage, okay, from the client. So when these two elements, i.e. the first one is that the two parties have, a special relationship, and the second thing is that, okay, the first party has obtained a manifest advantage from the second party, the law will just presume that the first party, in this case the lawyer, has in a way, okay, exerted some undue influence on the second party, or put simply, the law presumes that, okay, the lawyer has taken advantage of the client so that the contract in question will have to be voidable. Will that presumption be absolute? The answer is no, okay. This presumption of undue influence, it is rebuttable if the lawyers want this contract to be upheld rather than being declared void. The lawyer will have some weight. The lawyer will have to prove that, well, he has not, taken advantage of the client. He has not abused his position, okay. For instance, he can prove that, well, he has given full explanation, okay, of the real value of the land, but the client has voluntarily agreed to sell it to the lawyer at that price. The lawyer can also show that, well, the lawyer has advised the client to even consult other lawyers, so that, the decision, okay, to sell the land to the lawyer, it is a voluntary act of the client. If the lawyer shows this kind of thing, then the lawyer in a way rebuts the presumption of undue influence, okay. So the contract between the lawyer and the client will have to be upheld. The contract will not be voidable, okay. So we can see that, this doctrine of undue influence is not found in Thai law. We have seen, the doctrine of what? The doctrine of Duress and the doctrine of undue influence in English law. So from our journeys into the doctrines of Duress and the doctrine of undue influence in English law, we can see that, that these two doctrines in English laws appear to be broader than what we have seen in the Thai law. Okay, these doctrines in English law can offer much greater remedies, okay, to two parties. Than the principles of contract law in the civil and commercial code of Thailand. Okay, look at the doctrine of Juristic. Okay, we have seen that the doctrine of Duress in English law is much broader than the principle of Duress in Thai law, okay, because what? Because the doctrine of duress in English law is what? Is so broad as to cover even economic duress. Remember, all threats will be regarded by English law as duress if the threats, okay, lead the other party to the no practical choice situation, right? The threats can be a threat to what? A threat to cause bodily harm, a threat to cause harm to property, or even a threat to cause economic catastrophe on the other party. Okay, so all threats will be regarded by English law as duress, right? What about in Thai law? Does the principle of duress in Thai law cover on, say, economic duress? I doubt it, okay? Because if you can recall, the principle of law regarding duress in our civil and commercial code uses the word danger. Okay, what is duress in Thai law? According to the civil and commercial code, duress is a threat. Duress is a threat which causes what? Which causes an imminent danger. Okay, when Thai law uses the word danger, it tends to be perceived of as meaning a danger to what? A danger to the person. Okay, a danger in the way of causing bodily harm, or a danger to property. Okay, the danger to property. Okay, that means the property damage. Okay, can it be perceived of as meaning, any harm in an economic sense? Can it be perceived of as covering economic catastrophe? I doubt it. Okay, so by the use of the word danger, it doesn't seem to be interpreted so broadly. Okay, to cover the sort of the economic catastrophe on the other party. So the situation which is concerned with economic duress cannot be covered by Thai law. Okay, it might I should say the word might. It might not be covered by Thai law. Okay, so the perception is that the doctrine of duress in Thai law, okay, will not cover the situations which are concerned with economic duress. That is one limitation which we can see in Thai law. Now, what else? If we look at the English doctrines of duress and also the English doctrine of undue influence, we can also see that these two doctrines, okay, cover situations which do not constitute duress in Thai law as well. What situations are not considered by law as the situations which are concerned with duress? Put simply, what threats are not regarded by Thai law as duress? Well, if you can remember, there are two threats. Two threats which are not regarded by Thai law as duress. The first one is a threat to resort to the normal exercise of a right. Right, remember. Let's say that that if you commit a crime against me, and I say, well, if you do not want to be put in jail, if you do not want me to just bring the criminal action against you, why don't you do this? Why don't you sell your car to me? Something like that. Okay. So that if you just sell your car to me, you can't claim that the sale is made under duress, because a threat to resort to the normal exercise of a right is not regarded by Thai law as duress. But if you can remember, okay, if these situations occur in in England and English law applies, then this is also regarded as what? Regarded as duress. The contract in question may be declared voidable on the ground of duress and also on the ground of undue influence. Okay. The second threat, which is not regarded by Thai law as duress, is what? It is a reverential fear. Right. So that if let's say that you are my boss, and when I sell my car to you, because I am afraid that you will be upset if if I don't want to sell my car to you, that is a contract which is made under, a reverential fear. A reverential fear is not regarded by Thai law as juris. Okay, so but in this case, right? If you look at what happens in the English law, the doctrine of undue influence may be of help. Okay, let's suppose that the two parties, you and me, okay, you are my what? You are my. Let's say that change from the fact from from what the boss and the employee into the lawyer and the client. If you as a lawyer, okay, you want to buy the land from me, and I'm afraid that if I do not want to sell my land to you, then you, a lawyer, will be upset, and then this might cause some effects on on the litigation. Okay, so I have some reverential fear. In this case, when I just sells the property to you, due to this kind of reverential fear in this country, in Thailand, if we apply Thai law, this is not regarded by law as juris. But if this happens in the UK and English law applies, okay, if there is a contract between a lawyer and a client, this contract may be pronounced by the court as what? As voidable on the ground of undue influence if the first party and the second party have some special relationship, and if the contract confers upon the first party a manifest advantage. If I just sell my land to my lawyer at half price, in this case, my lawyer has obtained a manifest advantage. We say that this contract will be voidable on the ground of undue influence unless the lawyer can prove that he has not taken advantage of the client. Okay, so English law may be of help while Thai law offers no help at all. Okay, so from this slide, it tells you that that if we compare the positions in Thai law and the positions in English law, we can see that by and large, okay, English law seem to be much broader. Okay, the doctrines in English law are much broader than the principles of law as contained in Thailand's civil and commercial code. Okay, so now I would like to ask you the question, and you have to just consider this question very, very carefully. Okay, because I might ask you this question in your midterm examination. You are going to have your midterm examination in a few days' time. In fact, okay, so you have to think about this question, okay, right now, okay, rather than thinking of it in your examination time, okay. Is there any room for making amendment to Thai law in order that some provisions, the 11 provisions of the civil and commercial code of Thailand, okay, can be the fairer to the parties involved? Some provisions of Thai law are not quite appropriate. They have some deficiencies. They may not be able to protect parties who are disadvantaged. Okay, so there are some situations where provisions of Thai law may offer no help, while English doctrines, okay, that offer some help. Okay, so that means that provisions of Thai law may contain some deficiencies. So is there any room for making amendment to the provisions of the civil and commercial code of this country in order to be fair? Okay, so this is a question which you will have to answer if I ask you this question. Okay, I do not promise that I will ask you this question, but if I ask you this question, you will have to present a very, very good answer, okay, to this question. Okay, so that's it for the lecture today. I hope that my explanation of some doctrines of English law will broaden, okay, your horizon. Okay, so that you will see something more than what you have seen in Thai law. Okay, so I hope that it will be useful to you. Okay, thank you very much for your attention. Okay, and I will see you again. Okay, we are going also to explore one more doctrine in English law, the doctrine of mistake. Okay, so that we are going to have discussion of that next time. Okay, so today, thank you very much for your attention and see you very soon. Thank you. Have a good day.